And let the video upload real quick. All right, here we go. This is Trump and the GE on the Stock Exchange, of course, and this is Trump appeals Fani Willis election interference case in Georgia. So this document came out earlier today. This is what everybody's been waiting for. This is what all the drama's been leading up to. All the charges of impropriety between Fani Willis, the Fulton County DA, Nathan Wade, former special prosecutor on the RICO case, and Miss Willis's boyfriend, if you can believe that. She put someone she was romantically involved in with a special prosecutor on a high-profile case like this. And so, a lot of back and forth about whether she should be disqualified or not. So, the judge on the case, Scott McAfee, sort of split the baby and told either Miss Willis or Mr. Wade that they had to recuse themselves from the case. Mr. Wade's off the case, and Miss Willis is still on the case. So there's a court of appeals. Donald Trump, Rudy Giuliani, Mark Meadows, Jeffrey Clark, Robert Chile, Michael Roman, James Schaefer, Harrison, Floyd, and Kathleen Latham have filed an appeal to the case. And so this appeal was allowed to go through after all the back and forth about potential impropriety and other things. So this is their attempt to get the case dismissed, and before even going to trial. So I'm going to walk through some of the broad points. Came out pretty quickly. They got a bevy of lawyers on this case, and this case is unusual in that usually the state has an advantage. That's why defendants are considered innocent and proven guilty, because the state has unlimited resources. Trump and his legal team have almost unlimited resources. They got the media. They got this, obviously Trump is well funded. The co-defendants are well funded. You have the Republican Party of Georgia, the Republican Party nationally, all looking into this case and trying to get this case dismissed. And they're throwing all resources at this case. Bloggers, lawyers, everybody. Corporate media, everybody. So this is the broad points of the case. So they're saying that the argument is the application should be granted because the erroneous failure to disqualify a prosecutor pre-trial is a structural error and a due process violation. The application should be granted to provide this court with the opportunity to clarify precedent and the forensic misconduct standard for disqualification of a prosecutor in Georgia. It's a lot of odd things, a lot of potential precedents for this case because, in my opinion, this is probably a 100-year event to bring a election interference case. How many times do you see this? Maybe once every 100 years. Under point B, DA Willis's extrajudicial statements are disqualifying forensic misconduct, and DA Willis's submission of a false statement and false testimony is disqualifying this forensic misconduct. Then point C is the order's failure to found an actual conflict in its proposed remedy for the appearance of impropriety is erroneous under Georgia law and will cause substantial error at trial. Then under point C, it says the trial court error in determining DA Willis had not acquired a personal stake in this case. The trial court error by determining no actual conflict of interest is just based on its own fact finding, and the trial court error by refusing to disqualify DA Willis for the appearance of a conflict or impropriety. Okay, so I'm going to go through these broad points as quickly as possible, okay? Okay, go through the introduction. It says, first, the erroneous failure to disqualify prosecutor is a structural error that would not just cause substantial error at trial, it would render each and every trial in this case a nullity. Given the complexity of this case, the fact that it will likely be conducted through multiple different trials, given the number of defendants and the projected length of each of these trials, the time and resources the courts and the parties and taxpayers of Fulton County are going to be forced to expend to go through this process even once is massive. So I guess they're trying to make the argument of judicial efficiency. This could be very taxing on the taxpayers, and why go through all this when you can just dismiss the case? Why go through all this rigmarole? It's going to be very costly and time consuming for the residents of Fulton County, Georgia, who could have other better things to do with their tax dollars. Second, the need to establish precedent in this case regarding the disqualification standard for forensic misconduct is manifest. Okay, this could set precedents for how prosecutors should conduct themselves more and based on the law and the facts, and not based on publicity and performances, public performances, politics, and partisan behavior. That's how I read that. Third, the trial court expressly found D.A. Willis's challenge actions, including hiring her paramour, Special Assistant District Attorney Nathan Wade, as lead prosecutor in this matter, and accepting gifts and trusts from him that were funded through his compensation as lead prosecutor, created an appearance of impropriety that cast a pall over these entire proceedings. Okay? There's no way are these interests more important or on display than in a high-profile case like this one that has captured the attention of the nation. Crucial to the public's confidence is that prosecutors remain and appear to be disinterested and impartial. And it goes into the background, which I won't go into. We all know about Michael Roman's objection to the relationship between D.A. Willis and SADA Nathan Wade, and whether it was improper or not. It does go into say that Miss Willis, injected racial bias into the case, which as a lawyer you should not do. It says on January 14, 2024, only 6 days after the Roman motion was filed, D.A. Willis, reading from prepared notes, gave a speech at Big Bethel Church, a historical black church in Atlanta, which was televised by local and national news media. In that speech, D.A. Willis, while concealing her personal relationship with Wade, improperly injected race and racial bias into the case, indicating that defendants and their counsel were racist for challenging her unethical conduct, that defendants were guilty and would be convicted, boasting about her superstar team with a conviction rate of 95% who win, and implying that God himself had chosen her for this case and that he was on her side and that she was doing his work in this prosecution. All right? So she did say that she had three, main lawyers. One was Wade, who was black. Other two lawyers who were white. One was a RICO expert. But they only questioned the credentials of the black man. Why would that be? And come to find out that Terrence Bradley, which I'll get into later, Nathan Wade's business partner, was the one who told Roman's defense attorney, Ashley Merritt, that Nathan Wade and Fani Willis had a personal relationship going back to, I think, before this case started, and wanted to know if he needed a lawyer and was he in trouble, whether he needed a lawyer also. I think he had done business dealings with Wade as well. So he was the one who, it wasn't the defense attorneys who raised it, it was Nathan Wade's business partner who's acquainted with both, obviously, Wade and Fani Willis. He was the one who introduced us to the case. And they're saying that, the evidence of the hearing, basically that at the evidentiary hearing in February, both D.A. Willis and SADA Wade similarly testified under oath that their romantic relationship began around April 2022. The evidence at the hearing, however, demonstrated otherwise. Furthermore, D.A. Willis and Wade both testified a wholly unsupported explanation of cash payments without any documentation of payments or the source of funds, which, despite the fact that they are both attorneys, and the fact that D.A. Willis, as an elected constitutional officer, has strict reporting requirements that require her to keep track of any expenditures on her behalf that exceed $100 in any given year. In fact, her disclosures for 2021-2022, D.A. Willis certified that she had received no gifts or benefits in the yearly aggregate of $100, even though the undisputed evidence shows that she received a benefit of $1,000 from Wade, who was a prohibited source. The trial court criticized D.A. Willis's conduct in testifying at the hearing on this matter as unprofessional. Her overall conduct has a tremendous lapse in judgment over which the odor of mendacity lingers. Those are very strong statements from Judge Scott McAfee. An odor of mendacity, basically almost saying she's lying or making up these fantastical stories. You never want to have someone say that about you in a court of law, especially if you're a prosecutor. The trial court labeled the cash payments as unusual and lack of supporting documentation understandably concerning, and the trial court went on to further characterize it as a financial cloud of impropriety. Stopping just short of calling their testimony regarding these alleged cash payments an outright fabrication, the trial court half-heartedly said that her testimony on this issue was not credible as to be inherently unbelievable. Was not so incredible as to be inherently unbelievable. Okay. Despite the damning findings, there was a significant appearance of impropriety. Instead of disqualifying D.A. Willis, the trial court punted, D.A. Willis's numerous legal and ethical violations to other forms or sources of authority, such as the General Assembly, the Georgia State Ethics Commission, the State Bar of Georgia, the Fulton County Board of Commissioners, or the voters of Fulton County, to offer feedback on any unanswered questions that linger. It says, inexplicably, the trial court then permitted D.A. Willis, the very person whose actions created the appearance of impropriety, whose explanation was not quite inherently unbelievable, whose testimony still harbors a question of being untruthful, who falsely claims she was talking about defendants in this case, who created the lingering odor of mendacity, to decide how to cure the significant appearance of impropriety that infects the current structure of the prosecution team, and attempt to purge this case of the appearance of impropriety and the lingering stench of lying and falsehoods in her and SADA Wade's testimony. This is like a lawyer writing this. Thus, this case carries forward with D.A. Willis still in charge, regardless of the continuing appearance of impropriety, as long as she and her office remain involved. So they're saying the appearance of impropriety is still there as long as she's involved. And they kind of went to the source to have her cure it. The problem that they're saying she created. Okay. Okay, it says here on point A, the application should be granted because of erroneous failure to disqualify prosecutor, pretrial structural error, and due process violation. So they feel like their due process is being violated. It says due process also requires that the accused receive a trial by an impartial jury free from outside influences, including adverse publicity. Given the pervasiveness of modern communication and difficulty of facing presidential publicity from the minds of the jurors, the trial courts must take strong measures to ensure the balance is never weighed against the accused. Okay. So it's saying they've been, this case has been tried in the media, particularly with Ms. Willis's speech or her sermon at the Big Bethel Church. That didn't work in her favor, discussing the case like that. Then it says point B, the application should be granted to provide this court with the opportunity to clarify precedent and the forensic misconduct standard for disqualification of a prosecutor in Georgia. So they're questioning her truthful testimony here, which I've already discussed briefly. The odor and mendacity, so on and so forth. It says here that, talking about standard for disqualifying pre-trial forensic misconduct and a broader but necessary application of the principles set out in this one case called Williams is logical. A prosecutor appearing on national TV to malign and disparage defendants is not rendered consistent with due process and her ethical obligations merely because she refrains from explicitly saying they are guilty of the crime charged and only strongly intimates it. So she has, in my opinion, I've seen her on TV talking almost like not impartially, someone who's trying to make sure the truth emerges, but sound like someone almost like a politician, like she's speaking for the Democratic Party against political opponents, in my opinion. That's how it comes across sometimes. Like she's going after these guys. She's gonna get these guys. Like it doesn't sound like she has some. It sounds personal in some ways, in my opinion. It says DA Willis' extrajudicial statements are disqualifying forensic misconduct. And it says this case called Williams instructed that courts must look to whether the statements were part of a calculated plan, evincing a design to prejudice the defendant in the minds of jurors. DA Willis' statements and conduct demonstrate just such a design to prejudice the defendants. Here, while many of DA Willis' extrajudicial statements during this case are alone sufficient forensic misconduct to warrant her disqualification, one in particular stands out: the DA's prepared speech delivered before the congregation of a historical Black Atlanta church on January 14, 2024, as the trial court noted in its order. In these public and televised comments, the district attorney complained that a Fulton County commissioner and so many others questioned her decision to hire SADA Wade. When referring to her detractors through the speech, she frequently utilized the plural they. The state argues the speech was not aimed at any of the defendants in this case. Maybe so, but maybe not. Therein lies the danger of public comment by prosecuting attorney, by including a reference to so many others on the heels of defendant Roman's motion, which instigated the entire controversy. The district attorney left that question open for the public to consider. More at issue, instead of attributing the criticism to a criminal accused general aversion of being convicted and facing a prison sentence, the district attorney ascribed the effort as motivated by playing the race card. She went on to frequently refer to SADA Wade as the black man, while her other unchallenged SADAs were labeled one white woman and one white man. The effect of the speech was to cast racial aspersions as it indicated defendant's decision to file this pre-trial motion. And they're saying under Williams, it's one case they keep referring to church speech alone as disqualifying forensic misconduct. That could be interpreted that way. I mean, could she have prejudiced jury against these defendants? Maybe. Sound like she wasn't talking about the defendants. Sound like she was talking more about the defense attorneys. My personal opinion, I don't think she was trying to prejudice anybody against the prejudice the jury. I think she was just more trying to clap back at these people questioning her her integrity and questioning her relationship with Nathan Wade, and like grandstanding. And she seemed like she's a publicity hound. Like she wanted it. Like she likes the fight and she likes the publicity and she likes going back and forth. And the spotlight all on her at Big Bethel Church on Sunday and the national media there. And she sounded like a preacher. I was kind of impressed with her sermon, but she sounded like a preacher. And she wanted this, seemed like. Like it's more like a personal thing, not necessarily to prejudice the jury against the defendants, but it just seemed like she likes the publicity, likes to be on the public stage. That's my impression. Doesn't mean it's true. That's just my impression. Okay. But it could have the effect of prejudicing the jury against the defendants. And she should not have done that, but water on the bridge now. D.A. Willis' submission of a false statement and false testimony disqualifying forensic misconduct. So she knowingly filed a false sworn affidavit of former special prosecutor Nathan Wade as part of the state's response to defendant's motions, and she lied to the court under oath in her testimony before the trial court, as did former SADA Wade. Alarmingly, the evidence demonstrates that even after being rebuked for her improper and unethical behavior, in this case by both Judge McBurney in his July 25-22 order, and again by Judge McAfee in March 2024, D.A. Willis is still utterly unrepentant for her individual misconduct and that of SADA Wade. Defendants maintain that dismissal is a truly appropriate remedy because the disqualification of D.A. Willis and her office cannot fully undo the damage caused to defendants and their due process rights. So it's saying they've been denied their due process because she's prejudicing the court against them with the constantly public statements about race, and they're going after the black man, and the defendants are racist, or maybe the defense attorneys are racist. They are racist, and they're going after the black man, and it's all racially motivated. Even though it was a black man who was the one who dropped the dime on Fani, Willis, and Nathan Wade, and his business partner, and someone who she's acquainted with. I don't know if he had some personal agenda or he was afraid he was in trouble himself, but he was trying to get himself out of hot water, any potential hot water, and he was more than happy to throw them under the bus. So, those are the facts. Ashley Merritt had no idea about this. According to her, she had no idea about this relationship until Terrence Bradley told her. Okay, it says that Part C says the order's failure to find an actual conflict in its proposed remedy for the appearance of improprieties erroneous under Georgia law. As noted, the erroneous failure to disqualify prosecutor who has acquired a personal stake in the litigation through either an actual conflict of interest or an appearance of impropriety is structural error subject to automatic reversal. Okay, under C it says Part 1, the trial court erred in determining D.A. Willis had not acquired a personal stake in this case through her actual conflict of interest. D.A. Willis acquired personal disqualifying interest, necessitating her disqualification from this case. A personal disqualifying interest can arise from either a natural conflict of interest or an appearance of a conflict of interest. It says lawyers must avoid even the appearance of impropriety. D.A. Willis hired her paramour as lead prosecutor in this case and put him in a position to be paid over $650,000 by her at the taxpayer's expense. Compounding this problem, D.A. Willis then directly benefited from hiring her romantic partner. S.A.D.A. Wade paid for lavish vacations around the world, funded from the $650,000 D.A. Willis paid him, ostensibly because they knew it was wrong and conflict of interest. D.A. Willis and S.A.D.A. Wade actively hid their romantic relationship and financial relationship from virtually everyone, the public, defendants, and the courts. And when questioned about these benefits, both D.A. Willis and S.A.D.A. Wade gave false testimony to the trial court in an attempt to cover their tracks. D.A. Willis allowed her private interest to overtake and compromise with public duties, resulting in an actual conflict of interest. So when they went to court, there was no paper trail. We know that Nathan Wade took money out of his account, and she said she always compensated him, repaid him in cash. There's no paper trail whether she personally benefited from these lavish vacations, cruises, dinners, what have you. There's no evidence of it. Was her testimony fantastical? Seemed out there, but there's no proof that she didn't reimburse him with cash. And she said she had cash laying around the house. Just keep cash on hand, because her father always told her to keep cash on her all the time, like 6 months worth of cash or something that you may need in case of emergency. And that could be a straw man argument. That has nothing to do with the facts, but maybe her father did tell her that. But then her father testified, who was an attorney. He testified and said that's a black thing. That's a black thing. All blacks are told to do that. I'm not sure if he took a survey or what. They're all black, told to keep cash on hand. So that's where they always go to that thing, the black thing you wouldn't understand. And how would Judge McAfee verify that? And how would Ashley Merritt, Trump, Rudy Giuliani, Michael Roman verify that? They're not black, and they probably don't have that close a relationship with black folks to verify or deny those allegations. But her father says all blacks are taught to do that. We all do that. So I don't know this man. I don't know if he took a survey or what. But anyway, the testimony is very entertaining. But you can't. There's no paper trail that shows she benefited personally or that she didn't reimburse him with cash. Even there's no evidence of it. So there's a movie called Fort Apache, the Bronx. A famous movie. When I was a kid, I wasn't supposed to be watching it. And there's a famous scene from that movie where this officer chased this black guy. I think he chased him off a roof up in the Bronx or something. And he couldn't catch him. And Danny Aiello was more of an experienced cop. It seemed like kind of like played on the edge. And they were telling him the story. They were telling Danny Aiello the story about how he chased this black man off the roof or something. He was running down the alley. He didn't want to shoot him in the back because it would look kind of bad. You shouldn't have gotten in the back who's not a threat to you because he's running away from you. And Danny Aiello said, You catch a heart attack before you ever catch a blank. I remember being very, I was in grade school. I remember, what in the world did he just say? He said that in a movie, and it's a famous line. You catch a heart attack before you ever catch a... You chase this guy? Danny Allen, so you chase this guy? So yeah, you catch a heart attack before you ever catch Fani Willis. You're not going to catch her slipping. So it's pretty obvious. So she came out with a trick bag on that witness stand about this cash thing. I reimbursed him with cash that I didn't take out of the ATM, but I had it laying around the house in a vault somewhere. So yeah, you didn't catch Fani Willis slipping. I have a begrudging anyway. You're gonna catch her slipping. I'll put it like that. Okay, so they're making an allegation, but I don't think there's any proof, any hard proof. We can't, it's kind of nod, wink, wink, but they seem very, very squirrely. She and Nathan Wade, in my opinion, seem very squirrely. Okay, the trial court erred by refusing to disqualify D.A. Willis for the appearance of a conflict or impropriety. Okay, when there's an appearance of impropriety such as those the trial court found here, then disqualification must follow, as this court has found. This concept makes sense intuitively and in the context of existing Georgia case law. If private lawyers are disqualified from representing their clients based on a finding of appearance of impropriety, so too are prosecutors, who are held to even higher professional standards and are required by due process to be disinterested. This is important because if they can disqualify Ms. Willis, her whole team gets disqualified, and we know that's the end of the case. Nobody's taking this case. They can disqualify Ms. Willis. Nobody in Georgia is taking this case. Nobody wants it. Nobody wants to put their career on the line for this case. It's a high-profile case. You're not prosecuting Young Thug or YSL. You're not prosecuting high school teachers who were in a cheating scandal. These people have resources. Donald Trump has resources. He's battle tested. He's probably been in court. He and Don King probably been in court more than anybody in the country. He probably feels more comfortable in court than he does outside of court. He's battle tested. He's been through this process before. He knows how it works. He probably knows more about the legal process than most lawyers. Rudy Giuliani created the RICO. He was the one who perfected the RICO statutes, bringing criminals to trial and prosecuting criminals in New York, and prosecuting criminal organizations in New York. He perfected the RICO statutes. He knows more about RICO than anybody. And they have unlimited resources. They have defense attorneys. They have the Georgia Republican Party, and every lawyer in Georgia who's a Republican looking at this case and trying to get it dismissed. The National Republican Party, Jim Jordan, looking at this case. They got Marjorie Taylor Greene on the case. They got the Lieutenant Governor on the case. They're trying to get Brian Kemp and Chris Carr, the state AG, to find ways to get this case dismissed. This ain't something you really want. And it's not the hill most people want to die on, especially in the state of Georgia. So if they get Ms. Willis disqualified, they know the case is over. Everybody knows that. That's why they're fighting to get her disbarred. That's what the fight's over. She goes, the case goes with it. Okay, so they keep harping on this, her being disqualified because of the appearance of impropriety. And it's also important because, again, it was Terrence Bradley who said that they had a relationship before 2020. And apparently that's a line of demarcation because I guess they can say that he was hired first because of his qualifications and then they got involved. Where if they were involved prior to that, maybe she was required to get him his certification or something that required to get him certified to take the case of special prosecutor or its appearance of impropriety. But one would think that she should have reported the relationship as soon as it happened, whether it was 2020, 2021, 2023, whenever. She should have reported it, one would think. But it was Terrence Bradley who said they were involved before 2020. He stood on that, and then he walked it back. He walked it back when he was under oath. And he couldn't quite remember what he said, when he said it, when they were involved. I don't know if he walked it back because he got caught. Maybe he wanted to drop a dime on Nathan Wade and Fani Willis. Maybe he has a personal vendetta against Nathan Wade. Maybe they had a falling out, which happens among business partners. That's more normal, it's more usual than unusual for business partners to fall out. Maybe he got some axe to grind against Nathan Wade. Who knows? Or maybe he thought he was in hot water. Because I think Ashley Merritt, Michael Roman's defense attorney, clearly said that he asked her, am I in trouble and do I need a lawyer? You have a lawyer asking Trump's defense attorney, do I need a lawyer? That's how scary this guy is. If there were awards for playing a scary black man in a movie in 2024, he'd win it, hands down. That's how scary Nathan Wade, that's how scary Terrence Bradley is. And maybe when he realized he was in hot water, maybe he walked it back. That's why he walked it back under oath. But he walked those comments back. He had a sudden lapse of memory. He could remember who said what to whom. His testimony also seemed very squirrely. But again, if there was a reward, an award for Scary Black Man, a movie, he won an Oscar this year. So even the person who told Ashley Merritt that there was a relationship, and he stood on it, walked those comments back. So he didn't repeat it on oath. So I think he repeated related by text messages, but when his time to perform, he walked those comments back. So, okay, that's basically it. So they're harping on two things. They're harping on getting her disqualified for the appearance of impropriety. They don't really tell the sources of information. They a couple things. They don't mention Terrence Bradley as a source of information because he's not. I guess he's not really a credible witness. At least under oath, he's not. I guess most scary black guys aren't that credible on oath. Secondly, again, they keep harping on this disqualification of Ms. Willis because she goes, there's no case. Nobody's taking this case in the state of Georgia. Those are the facts. And the other thing is that I noticed was that, this is what I expected to see. I thought, the guy, Harrison Floyd, he filed what was called a motion for certificate of immediate review a few days ago, which the judge agreed to hear. And his argument was that, his lawyer's argument was that the case should be dismissed because Ms. Willis did not get the referral of the state election board before taking this case. And so she was supposed to get when I had a show on this a couple of days ago. I think it was yesterday, actually. That procedurally in Georgia, she was supposed to get the state election board's referral before bringing this case. And she didn't do that. And it's error of law, according to him. That's what I expected this appeal to say. It says here in his brief, it says here, defendant Harrison Floyd asserts that the court erred in failing to recognize that the statute called 21-235 is a specific statute that overrides the general provisions of a statute called 1512 and 100. To be sure, the Fulton County District Attorney does have broad powers, but in an election-related case, those powers are clearly statutorily limited without a referral from the SEB. That's a state election board. And he says, but the Georgia legislature did not intend for the district attorney to act unilaterally without the SEB's involvement. The text of the statute is clear. The Georgia legislature intended a referral from the SEB before a district attorney can take action on a case. And here, no referral was given to the district attorney. So before you can bring a case for, I guess, election interference, you have to get a referral from the SEB, which they're saying the district attorney did not. There's a clear error of law. That's what I expected to hear in that appeal from Trump and Harrison Floyd and Giuliani. That's not there. Maybe Harrison Floyd's gonna make that claim, that case in another legal brief. I don't know, but it's not there. That's what I expected to see, which seems to be a clear legal error. So, a lot to unpack, a lot for the appellate judges to look at. So, but you got to hear first. Someone who's been following this case pretty closely for the past several months. So, this is the heat. We're asking people to subscribe to the channel, like and share the videos, because we're putting out real information on Trump and the GE that you're not getting in any other place else. And we take a position. We don't just read documents and rah and take a side, whether we, constantly cheer on Fani, Willis, or cheer on Trump. We give objective opinions and real information. This is the heat. This is Trump and the GE. Thank you for listening. Thank you.